Representative Srinivasan of the 31st District, you have the floor, sir.
Thank you, Mr. Speaker. Good evening, Mr. Speaker. Good to see you there.
Good evening, sir.
Thank you. I, too, in the hours we've been here in the chamber, been listening to this debate very intently, because I know a lot is at stake here. State employees are our neighbors. They're our friends. They are family for us. And in my case, a good number of them happen to be my patients as well. So we are talking about people who are the bread and butter of our state, hardworking citizens in our state. So this debate, this discussion, when we talk about the contracts, on whom it impacts, obviously the state employees, the concern we have is whom are we impacting? And we are impacting the very people that are our friends, our neighbors. But when I look at what is the compensation for somebody who is in a private sector and somebody who's in a public sector doing similar jobs, we have seen report after report that tells us that the pay scales are very equitable. But it's the benefits, the healthcare benefits and the pension benefits that stack up and make the staggering difference, where I'm told could be about 25 to 45% higher than what one gets in the private sector. So those are the concerns. To be equitable is what we need to do, given, as we've heard, and we know the crisis, the financial crisis that our state is in. The good chairman did say in his opening remarks, or maybe in some part of the conversation, that he was not at the negotiating table when these were discussed. And obviously, there are things that he's aware of, but not there at the table at that particular time. But through you, Mr. Speaker, what was the rationale that we are holding the next legislatures and the future governors of our state for the next 5 years by extending this contract? So how did we arrive that we were going to go for a 5-year extension? I'm not sure if it's a fair question to the chair because he may have not been at the table, but I'm hoping that he would have some insight on how we arrived at extending, because what we cannot afford to do is repeat the mistakes of the past. And I know it has been done, the mistakes have been done by Republicans in the past, by Democrats in the past, so I'm well aware of that, but our job is not to repeat those mistakes. So through you, Mr. Speaker, the basis of the 5-year extension. Through you, Mr. Speaker.
Representative D'Agostino, do you care to respond?
Yes, Mr. Speaker, thank you. So, again, I'm not going to put myself in the mind of the negotiators precisely, but I think you can look at the overall deal and make some logical conclusions. You're getting that massive impact of the wage freeze, not only in the immediate years, but the long term. And then we talked about, for example, the new employees. No security, job security protection. And think about this, what we talked about before. We haven't talked about it much in depth yet, but that new plan that they're in, this new Tier 4 that we're creating, right? That's a new part of the pension plan the new employees go into that has a defined contribution element, something I know a number of members in your caucus and even members of my caucus have been calling for. That's a significant structural, unique change that you wouldn't be able to get until, if you just waited for SEBAC, if you waited for SEBAC to expire, you wouldn't be able to get that till 2022. So they've agreed to accelerate that change to this year. New employee tier this year. No job security for that tier this year. Wage freezes this year. Last year, the following year. All those structural changes. As I mentioned in my opening, that's massive. Those are gifts. And so what do we give to get that? The two main components, the job security for the existing employees for 4 years, and that's where the extension of SEBAC for that 5. But in that extension of SEBAC for the additional 5 is that new tier. are the new structural changes, the Medicare Advantage, all these other pieces. So to me, when you talk about it and looking at it holistically, you're embedding all those changes into an extended deal. And again, I go back to what I said before, because again, there's just sort of been this not confusion on this point, but maybe a little bit of deliberate obfuscation, that we've locked our hands for 10 years. Yes, on SEBAC, where the most important structural changes are embedded. But that wage and hour and conditions, those expire in 2021.
Representative Srinivasan.
Through you, Mr. Speaker, we've heard about no layoffs. I mean, that's one of the requirements for this agreement to move forward. And in these no layoffs, I also heard the good chair talk about that when we reorganize and restructure, so that can be done. And in this process of restructuring an organization, a department, if those jobs do not exist anymore, what would be our liability? What would be our responsibility to those employees? Through you, Mr. Speaker.
Representative D'Agostino.
Through you, Mr. Speaker. So I outlined this previously. We could spend all night talking about this particular process, but since 1993, there's been something in place called a placement and training program agreement, right? And that typically applies for laid-off employees. So basically what we're doing is taking that structure and we're using it for restructured or reorganized employees. It says before they're restructured out of existence, they are given an opportunity to go through this process, placement and training program, just like a laid-off worker would be. Are they qualified for an opening somewhere else? If they are and they meet the various requirements of that program, they are entitled to that job. And so they can't just be restructured out of existence overnight. They've got to have, they are given the opportunity to go through that process. Again, a process that has worked well, that's been in place since 1993 for laid-off employees, that I think everybody really would concede leads to a more efficient workforce, because you're getting people in positions where they're needed and they're qualified for them. All right? And again, if they don't take that reassignment, then they're out of a job.
Representative Srinivasan.
Through you, Mr. Speaker, I get that. So when a reorganization happens and these employees now have to be moved because they no longer need to be in that department, and they can be trained and go into some other place. But at the same time, when we have a hiring freeze and those opportunities don't exist for them to go to some other department within the state, what then happens to these organizations which we do need to reorganize to be efficient, and they don't have any opportunity to go to? Through you, Mr. Speaker.
Representative D'Agostino. Through you, Mr. Speaker, again. So we've got here a history. We've got more than 20 years of this process working with, we've had job security guarantees before, we've had hiring freezes before, and the counterbalance to all that is normal attrition. Literally thousands of employees over the years. That's how we've actually managed to shrink the state workforce in the unionized state workforce in the last 10 years by 15%. So I'm confident, based on past experience, that scenario you're painting can easily be avoided, because given understaffing, given attrition, given retirements, you're always going to have that flow and be able to move people in somewhere. Now, if you don't, if that scenario occurs, that obviously has to be factored into whatever department's considering that, OPM. They're going to look at that before they make a decision. But again, given the short staffing we have in a number of departments, and keep in mind, for example, we're under a federal mandate with DCF, right, places like that, given attrition, given all those factors and that how this has worked well in these exact same scenarios for the past, well, since at least 1993, I'm confident it'll work here. That's why they adopted this. That's why they carried it forward. Again, these really are not new concepts. They're just being applied to the reorganizational scenario.
Representative Srinivasan.
Through you, Mr. Speaker, you have talked about the Medicaid, the Medicare plan, and my question is, when we switch over to the Medicare Advantage plan, it is my understanding from what I've heard from you that we would be having significant savings. But also we've seen reports, Mr. Speaker, where those savings do not happen at all. And so my concern or my question through you, Mr. Speaker, is what is the basis by which you feel confident that when these people are switched over to the Medicare Advantage program, we will see the cost savings? Through you, Mr. Speaker.
Representative D'Agostino.
I would only note this is something that I know the comptroller's been talking about for years that he's wanted to do based on the folks in his department. Siegel Consulting, the group that we used, again, that actuarial reports that have been available since June 6th, they booked it as well. And if I'm remembering this correctly, to be fair, the House Republican budget includes a shift to Medicare Advantage with savings attributed to it. So I think we all agree that those savings occur with a switch to Medicare Advantage. We can quibble about, again, as I mentioned earlier, whether you can do it unilaterally or not. That's a separate legal question. But based on all the actuarial reports I've seen, the comptroller's reports, our budget analysis, your budget analysis, Medicare Advantage leads to $200 million in savings in the biennium, and those savings increase over time after that. Long-term structural change.
Representative Srinivasan.
And through you, Mr. Speaker, I just want to touch upon the pension plans. So as I understand the present proposal, the employees on Tier 1 and Tier 2, there would be no changes moving forward till this contract is over. And what we will see, the changes in the pension plan, will be in our new employees starting as early as next month. Through you, Mr. Speaker.
Representative D'Agostino.
Through you, Mr. Speaker. Actually, no. There are changes to Tier 1, Tier 2, and Tier 3. Let me just summarize you, and I thank you for the question because this is an important point. It is not just, probably the most dramatic change is this new Tier 4 with a DC plan. But Tier 1 and Tier 2, they start immediately paying more based on when they retire for their premium share. That goes up in some cases. I appreciate that some of them were at 0, so some move, if they've got a POE plan, they go from 0 to 1.5, or a point of service plan, 1.5 to 3. So that's an increase in the share for Tier 1, Tier 2. That's all Sears levels, all state employee retirement system levels. And pension contributions. So for the few Tier 1 employees that we still have, and I think there might be 40 or so, but more importantly for Tier 2, where there's more significant number, and again, I mentioned this before, I don't think people are really aware of it. Tier 2's at 0 for their pension contribution. That's a relic of something that happened, I think, 40 years ago. They move up, again, this is all effective 7/1/17. They move up over the next 2 years by 2%. So we go from, for example, depending on what tier you're on, 2% to 4% or 0 to 2. That's from 17 to 19. I know that the percentages sound small, but when you do that cumulatively, it has a big impact. That's part of these overall pension savings. So there's structural change, not just for new employees, but Tier 1s, 2 and 3, and 2A as well.
Representative Srinivasan.
And through you, Mr. Speaker, in the calculation of these pension plans, was there any structural change? It is my understanding it is the salary, it's the overtime, it is the COLA, the built-in kind of, that return rate, fixed rate of return, and also mileage. All of those components go into the pension in a defining as far as the pension is concerned. So through you, Mr. Speaker, whether it's Tier 1, 2, 3, or 4, are there any structural changes in what goes into the pension calculations? Through you, Mr. Speaker.
Representative D'Agostino.
So, first of all, there's no mileage in pension, but let me address that, I guess, in a couple of different parts. When we talk about structural, we've already talked about some of the structural changes in terms of increased contributions. I consider that structural. The COLA change, effective, I believe it's 7/1/22, is significant as well. So no longer are you guaranteed a 3% cost of living adjustment if interest rates, if the CPIW is at 1.5, or it's been languishing for years and probably will for the foreseeable future. So you no longer get that automatic 3%. If it's below that, you get below that, and then there's a tiered structure with respect to 60% over, I think it's 2 or 3 to 6, and then 75% over that. I'll get you the exact numbers, but it's in the SEBAC agreement. So that's structural change that's embedded in this agreement. With respect to a pension itself, let's see if I remember this correctly, there's basically 3 different components to the pension, right? How long your years of service, and your multiplier, and I'm forgetting the third, but I'll get that for you. But the multiplier is a significant piece of the pension calculation. That comes down for the new Tier 4s. That multiplier, where it might be 1.5 for Tier 5, is now 1.3. Again, that is deep structural change that really impacts the cost of these pensions going forward. And that's why you see numbers like 300 million, 400 million, 500 million. The actuary takes all that structural change into account, and that's what impacts the actuarial required contribution and reduces it significantly. That's deep structural change on various levels.
Representative Srinivasan.
Through you, Mr. Speaker, are these structural changes that you just referred to, do they apply only to Tier 4, or would they be going all the way back to Tier 1 as well? Through you, Mr. Speaker.
Representative D'Agostino.
So it depends on which ones we're talking about. For the example, the multiplier example I gave is just Tier 4, but the COLA change, that's everybody. That increase of 2% in pension contributions, that's everybody. They kick in at various times, but most of those changes span the gambit of Tier 1s through 4, and then you've got some additional deep structural change in this new Tier 4 because it is created out of whole cloth, so we're able to do some more things with that.
Representative Srinivasan.
Thank you, Mr. Speaker. I want to thank the good chairman for his answers. And my concern still is, yes, he used a very appropriate choice of words, that we are not handcuffing for the next 5 years beyond when we extend this. But that's my concern, that yes, we have made changes. We have made structural changes. No question about that at all. There are definitely parts of this agreement, of the SEBAC agreement, that I could live with. But when I look at it in its totality, I'm not able to vote on parts of it, but have to vote for the whole bill. As a total, I find that it has gone far, but not gone far enough. Thank you, Mr. Speaker.
Representative Bolinsky of the 106th. You have the floor, sir.
Thank you, Mr. Speaker. Through you, a couple of questions for the proponent of the resolution, please.
Representative D'Agostino looks fully prepared. Representative Bolinsky, please proceed.
Thank you, sir. Was this agreement referred to or in any way reviewed by the Committee of Cognizance, the Appropriations Committee?
Representative D'Agostino.
Through you, Mr. Speaker.
No, not as far as I know. It was not submitted to appropriations. I think we've established that.
Are we not appropriating?
Representative Bolinsky.
Thank you, Mr. Speaker. So are we not appropriating money to an agreement for which we do not have a budget in place? Through you, Mr. Speaker.
Representative D'Agostino.
Well, I guess there's a technical answer to that and a general answer to that. The technical answer is we've got statutes that govern our conduct with respect to these agreements, 5-278 in particular, and the various subsections in there, all right? And those say that when we get an agreement presented to us, it has to be presented to us in a certain amount of time, which it was, and we vote it up or down. And then there's another provision in there that says if we vote it up or down, we allocate funding for it. So we, by statute, have laid out our structure for approving these agreements, separate and independent from an appropriations committee process. That process is not in statute. 278B governs our conduct there, and we're following that. And as far as I know, we haven't revoked that. So that's still in effect. So that's sort of that's the technical answer to your question. The more general answer, of course, is this is the linchpin to a budget. $1.5 billion in savings over the biennium. Long-term savings, structural change, predictable costs. this domino falls, I have no doubt we are going to have a budget soon. That's why we're voting on this today. So that's a technical and a general answer to the gentleman's question.
Representative Belinsky.
My thanks to the good representative for his answers. I don't share his optimism as far as us having a budget anytime soon, because if you take a look and you hear the people that are talking on this side of our aisle, we have been disappointed and been let down on 4, maybe 5 different occasions on being able to actually have a budget on which to vote. And that's concerning to me, but more importantly, Mr. Speaker, I'm asked by my constituents on a daily basis, when are you guys going to have a budget? When are you guys going to have a budget? And I tell every single one of them that, well, we, the House Republicans, have had a budget. As a matter of fact, we've on version 8 right now, because we keep updating it based on our current financial condition. Fundamentally, though, something that was said by the good representative very early on, several hours ago actually, when we were discussing some of the details of this deal, when we were talking about those one-time stipends, the $2,000 payments to every single one of the state employees for foregoing their raises, that $4.4 million one-time stipend was dismissed as being not a lot of money. I can't help but ask myself what my constituents ask me. When did it become easy to think about $4.4 million as insignificant? And all I can come back to is a certain lacking of the impact on the people that actually pay the bills in the state of Connecticut, which are the taxpayers. For goodness sake, it's easy to think that $4.4 million is not a lot of money if you're spending somebody else's money, for God's sake. So let's talk about this. We can't deliberate a budget. We get defeated on being able to talk about the Republican budget and then be able to dovetail that into real conversation about just exactly what's important to all of us, which is the financial and future success of the state of Connecticut. So rhetorically, I just got to come back to this question. Who the heck is looking out for the taxpayers of Connecticut? Where is their voice? And the answer to that question, ladies and gentlemen, should be it exists in us in the General Assembly. Going back to what Representative Lavielle said before, anybody that doesn't feel that it should be deliberated and voted upon to start the process of actually talking about a budget and coming to some sort of a resolution is unconscionable. And we should understand, and the public should understand, that after we pass this cart before the horse resolution for this union employee contract, which, by the way, I hope it doesn't pass because I won't be supporting it, the process of allocating these dollars without a budget in hand basically constrains the budget, and one only need listen to the news or read the newspapers to see that the intention is that the Democrat budget, when and if we ever see it, is going to contain significant tax increases. So again, who is the voice for the taxpayer of Connecticut? And to very, very strongly reinforce what Representative Lavielle had said before, those of you that vote for this and for a budget that contains significant tax increases to pay for this, which does not go nearly as far as it should, you wear this on your head. And when the next election comes along, I think the people of the state of Connecticut have had enough of the tax increases. So, to my colleagues on the other side of the aisle, think long and hard about this and what it's going to mean to you in November of 2018. So, we have subordinated a budget to do a union agreement that doesn't concede enough. So, extending an expired contract, giving 10 years of protection in a state that has zero credibility in predicting its financial present and future is way too big of a risk to, as Representative Iaccarino said, give it another 10 years. How dare we? So, sorry for being long-winded. Thank you, Mr. Speaker, for hearing me out. And to my colleagues, please represent the taxpayer.
Representative O'Neill of the 69th. You have the floor, sir.
Yes, thank you, Mr. Speaker. I have a few questions for the proponent of the resolution, if I may.
Please proceed, sir.
At the beginning of the conversation, the explanation of the resolution, and there was a mention made of the Republican budgets and of alternatives that excluded this proposal before us as essentially being illegal, that they would be subject to immediate lawsuits, that the collective bargaining agreements would be broken if we did various kinds of things. And one mention was made of the Rowland case as an example of what would happen, that the impairments of contracts clause would be invoked and under the U.S. Constitution, and there would be an immediate lawsuit if we try to do some of the things that the Republican House budget at least calls for us to do. And so I would first off ask the proponent if there is any reference in the case of the State Employees Bargaining Agent Coalition versus Rowland referring to the impairments of contracts clause. Through you, Mr. Speaker.
Representative D'Agostino.
Through you, Mr. Speaker, I brought up the Rowland case. Short answer is no.
Excuse me, Mr. Speaker.
I'm sorry.
I thank the member for his answer. There is no reference whatsoever in the Rowland case to the impairment of contracts clause.
I'd love to have been given a chance to finish my response
Yes.
before I was cut off.
Representative O'Neill,
This
the
is not a
representative
courtroom.
hadn't finished his answer yet. Representative D'Agostino, please proceed.
Thank you, Mr. Speaker. I brought up the Rowland case to illustrate what can happen when we are challenged by the unions and we can get adverse rulings against us. In that case, I think the liability is over $100 million, if I'm not mistaken. And when you're talking about in this scenario, facing an even higher legal hurdle with the contracts clause, as the good representative who's a very talented lawyer knows, and knows the standards of the U.S. trust case, that if we can't meet those standards, that we're really under the gun, exponentially, when compared to the Rowland case. Thank you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. Again, the Rowland case did not involve, there's no mention whatsoever of the impairment of contracts clause because the Rowland case was all about retaliation by a governor, not the legislature, against state employees by laying them off because the claim was made that the governor did not receive campaign support from the unions involved in the layoffs. And that was the basis of that case. Now, referring to the U.S. trust case, did that case involve a collective bargaining agreement through you, Mr. Speaker?
Representative D'Agostino.
The U.S. trust case did not involve a collective bargaining agreement. It involved the impairment of the state of New York's, I believe, its bonding or city's bonding obligations, or when compared to New Jersey. And in that case, the Supreme Court, as it does, laid down a standard by which you interpret whether or not a state has properly or not impaired its contract. And it is those standards, that three-pronged standard, that I'm sure the representative is aware of, whether it substantially impairs a contract, whether it is reasonable, and whether it is necessary to an important public policy. That three-pronged test, surrounded by a higher degree of scrutiny, applies whenever a state impairs its contract, just as we've been talking about today. So I appreciate that that particular case did not deal with a collective bargaining agreement, but there is no question, and I'm confident Representative O'Neill would agree with me, no question that that standard is what applies when you analyze a case under Article 1, Section 10.
Representative O'Neill.
Thank you, Mr. Speaker. Is there a case involving a collective bargaining agreement issued by the United States Supreme Court that states that a state has impaired the contract Through you, Mr. Speaker.
Representative D'Agostino.
Through you, Mr. Speaker, there's not a U.S. Supreme Court case, but there is precedent in this circuit, in particular the Second Circuit.
Representative O'Neill.
And the case involved in the U.S. trust case, which is the basis of this whole area of law, that case involved a bond covenant in the state of New Jersey that was impaired. One of the factors that was not mentioned is foreseeability. That one of the considerations that the court made was that if you couldn't foresee the changes in circumstances, that you had the opportunity then to legislate, because they were referring to an earlier case in which that was exactly what an earlier Supreme Court had held was permissible. So I'd ask the proponent, was it foreseeable in 1996 that the economic conditions facing the state of Connecticut were what they are today? Through you, Mr. Speaker.
Representative D'Agostino.
The standard of, where the standard of foreseeability comes into play is if there's something new. So let's say, and I'm not standing up here, I want to be clear, I'm not standing up here and saying that there might not be some occasion down the road, I think we talked about this, I was responding to an earlier question, if there's another financial crisis that is unforeseen at this time, that arguably would not preclude us from making a unilateral change under this three-pronged standard under U.S. trust. But that's a high hurdle. We couldn't just go in to court 2 years from now and say, yeah, you know what, tax receipts haven't really improved. We want to make a unilateral change to the agreement. That is exactly the type of change that the court found was foreseeable in the Second Circuit case, Association of Surrogates v. New York, 940 F. 2nd 766. So could there be some sort of cataclysmic financial event like we had in 2008 that occurs in 2020? God forbid that happens. Is that an unforeseeable circumstance that arguably, when lumped in with the other three factors, enables you to make a unilateral change to the contract? Maybe. I hope we never get there.
Representative O'Neill.
Thank you, Mr. Speaker. Well, actually, the problem is that we're not talking about 2020 and actions by the legislature then. The Republican budgets are talking about actions by the legislature now in response to the financial conditions which, as the governor has repeatedly described them in the last couple of years, represent a new economic reality that he was not aware of and had not been making plans around when he proposed the budgets that he proposed in 2011, 2013, and 15. What we're dealing with now is an economic reality where Connecticut is lagging far behind the rest of the country in job production or the recovery of the income, where our taxpayers are no longer paying the taxes that they were paying to the tune of hundreds of millions of dollars. And this is well documented by reports issued by the Department of Revenue Services, among many, many others, about the financial conditions of the state of Connecticut today, not in the year 2020. So the question is whether or not today we in the legislature could, for example, continue the de facto wage freeze that exists because the wage contracts have not been negotiated or not at least been ratified, that exist out there, and that have left us with a zero wage increase over the last year. That's the situation that we are dealing with right now, not some future problem which some future legislature might try to address by some future legislation. The implication, at least, and perhaps I misunderstood the proponent's comments, seemed to be that because we have collective bargaining agreements that contain language that say that there's, in effect, a continuation, a kind of tail that goes on and on and on after the contract expires, that we are barred from simply not renewing the contract or, as a legislature, from rejecting the contract. So let me ask this, through you, Mr. Speaker. Is the House of Representatives, is the Senate, is the Connecticut General Assembly prohibited by the collective bargaining agreements from rejecting collective bargaining agreements that call for wage increases. Through you, Mr. Speaker.
Representative D'Agostino.
Through you, Mr. Speaker, I don't want to suggest that by operation of these agreements and the extension clauses and 5278A that we are stuck in this perpetual loop of always having to approve and collectively bargain wage increases. That's not what I'm suggesting. What I am saying is that there's a very good legal argument that certainly, at least for fiscal year 17, that a union would have going into court to say, by virtue of that agreement and the obligation to bargain in good faith that you contractually agreed to extend, coupled with the statute, that there'd be at the very least a good argument with respect to fiscal year 17. After that, sure. If we want to get rid of collective bargaining for wage and hour, not pension and health care just yet, even I think the representative will acknowledge this, as has been stated before, and let's be very clear here. Current SEBAC agreements expires in 2022. That's where the contract clause attaches. You cannot just simply stop collective bargaining, pension, and health care until that contract ends at the very least. But yeah, putting aside the issue of the extension clauses, let's say we win that in court. We go to court, takes a year, we win that. Yes, you can get rid of collective bargaining for wage and hour. If that's the course we're going, as a purely legal matter, the answer is yes. As a practical matter, what happens? The whole deal falls apart. There are no savings in fiscal year 18 and 19. There is no long-term structural change. We wind up in court on a question that, again, I am not sure that we will win. But if that's the path that members of this body want to go down, we can go down it. It's a disastrous one, in my opinion. It's rife with legal risk, in my opinion. But if that's where you want to go, you can go there.
Representative O'Neill.
Thank you, Mr. Speaker. Now, talking about legal opinions, the statement that the legislature or the state generally is bound, at least through 2017, to apparently approve collective bargaining agreements that might contain wage increases, is that a question that was put to the Attorney General, who is the authority giving legal opinions for the state of Connecticut, through you, Mr. Speaker, to the proponent?
Representative D'Agostino.
I do not know if that question was posed to the Attorney General or not. I think what I can tell you with 100% degree of certainty is if this agreement is rejected, and we, as part of that, are obviously rejecting that obligation in the extension agreements, we will wind up in court. And I don't know what the Attorney General will say about our chances, but I can opine about our chances, he can opine about our chances, Representative O'Neill can opine about our chances, but ultimately, we're going to be in court, and a judge is going to tell us what the result is.
Representative O'Neill.
Thank you, Mr. Speaker. Well, the Attorney General is the one whose opinions are binding upon the state government, and certainly are for the administrators, and certainly have great persuasive weight for the legislature. On numerous occasions when we have considered legislation, the opinions of the Attorney General have been brought to our attention and have been sought to try to give us guidance as to what the appropriate course of conduct is and what our chances were in court. Now, what the proponent was talking about at an earlier stage of early on in the conversation was related to the Medicare Advantage program, and the idea that we cannot unilaterally change to the Medicare Advantage program without the risk of litigation. I believe the comment was made to the effect that this would constitute a very substantial change in circumstances, not a mere technicality. So I would ask if the language in the 2009 SEBAC agreement, which is still in existence today, and if I may quote, it's only about 4 lines, under Section 2F, Self-Insurance 1, the state may, in its sole discretion, provide health care benefits on an insured or self-insured basis or any appropriate combination of funding bases. Such decisions shall not be appealed or arbitrated in any forum by SEBAC, any constituent union, or state employee. Now, I would ask the proponent if this language is what it says it is, binding on the union and prohibitory of any challenge to the state if, in fact, it were to make a change in its sole discretion of the health care benefits, either insured or to some other appropriate combination of funding bases. Through you, Mr. Speaker.
Representative D'Agostino.
So obviously, anytime there's a change, the benefits have to be the same. So again, if you're changing that structure as you would with Medicare Advantage, that's a substantive change. So I take that kind of change outside of the ambit of that language, and I think it's very clear that a number of retirees might as well. And that's why I go back to the point I made earlier with respect to the litigation risk associated with that. Whether or not that language controls or not, whether or not you can make that argument, that's an argument to make in court. Do we want to take that litigation risk and potentially lose, like in the Rowland case, using that as an example of where we lose? Again, not a contracts clause case. So if we take that risk, it's all on us for the Medicare Advantage change if we do it unilaterally. But if we collectively bargain for it, we are no longer unilaterally making a change to a contract. It is an agreed upon change. We are thus immune from liability under sovereign immunity because we can't be sued under the contract clause because we're not making a unilateral change to a contract. And the union bears the entire risk for that argument. Again, that I can't underestimate the importance of the litigation risk on a change that both sides of this aisle want. Getting the change we both want, Medicare Advantage, but eliminating the litigation risk for the state of Connecticut.
Representative O'Neill.
Thank you, Mr. Speaker. In the language that I read, is there any reference? There is no reference, I will say this. There is no reference to an exception relating to substantial changes. It's pretty clear that the state may, in its sole discretion, provide health care benefits on an insured or self-insured basis, or any appropriate combination of funding basis. Now, this is language that's in the SEBAC agreement that exists today. If we cannot rely on this language to protect us from future litigation, I do not understand how the language in 2017 SEBAC agreement is going to be any protection either. If this language, which was negotiated in 2009, was part of a collective bargaining agreement that was agreed to by the union, does not protect us, I don't see how any language that's put into any SEBAC agreement is able to protect us. So either this language protects us, or it doesn't. Either this language is a contract that's binding on the union just as much as all the other provisions are binding on the state, or it's not. If any party can at any time choose to look at these agreements and say, well, that's not what I meant, I'm going to go to court and sue you and perhaps get hundreds of millions of dollars in damages, I don't understand what the value of the SEBAC agreements are at all. You can't have it both ways, Mr. Speaker. You can't say that this language doesn't really mean anything, that it's somehow merely technical, and that it doesn't hold up in court, and then turn around and say, but this new language from the 2017 agreement, that's binding. That's something we can really trust. That's going to avoid us getting sued by, apparently, a group of people who might have a reason to want to sue us, the retirees. If this language doesn't protect us, how does the new language protect us? I don't see how it could possibly protect us, Mr. Speaker. To say that all of the changes that the Republican budget seeks to make, which can be implemented by administration, which are pursuant to the SEBAC agreement, where we reject contracts which are called for under our statutes. We have the right to reject contracts. We have the right to reject arbitration agreements if there is insufficient funds. To say that none of that matters, because it's not collectively bargained, and then to say that the collective bargaining agreement that we already have, that doesn't matter either. this has a kind of Alice in Wonderland, topsy-turvy quality to it, Mr. Speaker. That the language means what the unions want it to mean, and when they want it to mean something else, then it means something else. And it doesn't mean anything as far as protecting the rights of the people of the state of Connecticut. It only means something in terms of protecting the rights of the union workers. It cannot be that the legislature does not have the power to do anything significant legally without the permission of the public employee unions. But it sounds to me from the conversation that we have had, from the explanation given by the proponent of the agreement, that that's what it is. The legislature might not as well exist, just the collective bargaining agreement, because it governs everything. It has to be that we have some role to play in the formulation of the state budget. Now, a final comment, Mr. Speaker. The governor proposed that $1.5 billion number at a time when the budget was estimated to be about $3.5 billion out of balance. Then we discovered that it was more than $5 billion out of balance. And the $1.5 billion number to help correct the imbalance never changed. What the Republican budget calls for is, in effect, an adjustment so that the share of the burden for the state employees would rise in proportion to the size of the deficit. The governor called for about a 40% share by the state employees originally, and that's really what we are calling for in our budget. Otherwise, somebody else has to make up those extra $1.5 billion, all of it being borne by taxpayers. This agreement locks us in to an impossible situation. If we approve this agreement, if this agreement becomes law for failure to approve it, then the state of Connecticut is locked in for the next 10 years on the SEBAC side of things. And I'm not quite sure how it is that 2017 we are obligated by the tail ends of the contract, by the continuation agreements, but somehow that's not going to be a problem in 2019 or 2020. Either we are handcuffed by the existing wage agreements or we're not. It cannot be that we're handcuffed this year because we're considering this matter today, but we're not handcuffed 3 years from now when we are being given the hope that maybe we could make some changes. There is a complete contradiction, in my opinion, in the presentation of this SEBAC agreement as to what its impact is and what our legal requirements are right now under the existing agreement and what our legal rights are right now. Seems like we have no rights, we only have obligations to the unions. That cannot be. This agreement should be rejected. The governor should go back to the negotiating table, and he should get a better agreement for us that where the share of the burden is proportional to the size of the budget in the same percentage that it was originally. He asked the unions for about 40% of the budget deficit to be borne by the unions. He should go back and ask for the 40% of the budget deficit to be borne by the unions. Thank you, Mr. Speaker.